First on the list is Mr. Schafer. Mr. Schafer. Okay, thank you, Mr. Schafer. Sorry about that. Mr. Schafer, if you could tell us your name, where you live, I believe if you're representing anybody, that as well in the organization, and tell us what you want to tell us.
Okay, thank you, sir. I'm John Schafer. I'm the director of the Grandparents' Rights Association of South Carolina. Live in Easley, South Carolina. And I'd like to just kind of give our viewpoint on 371 and H-3464. Basically, the way it is in family court right now for DSS cases that are grandparents are almost not mentioned at all in the law. There is one statute for visitation that is non-DSS related. This bill actually is really simple, but we feel like it's extremely important as it would give grandparents standing in the family court where DSS is involved, and also where there's a chance of termination of parental rights. Basically, it would give the grandparents the ability to stick their hand in the air and ask for custody or be able to help take care of the children. Where now, a lot of the family court judges simply feel like, since they're not really mentioned in that part of the statute, that they really have no rights. A family court judge so much has told me that exact same thing. I was told that when they take the rights from the parents, they take the rights from the whole family. At the same time, that's the way it is. They don't like it, but that's the way it is. And that's the reason for this law, or this bill.
Mr. Schafer, so basically the scenario, just to kind of boil it down, the actual scenario we'd be having here is that a child is taken by the Department of Social Services, and it'd be a situation where then there's a finding that there's probable cause to remove the child from the home. Is that right?
Yes, sir. And
then what you're asking is that the court could consider or should consider that a grandparent should be made a party, and the child, if everything else is appropriate, placed there.
Right. As it stands now, the DSS manual tells DSS to try to find family or close relatives to take the child to start off with. But by the time it gets to court, that's kind of lost.
Okay. But if a court found, for example, that a sister or an aunt was more capable because of whatever the individual circumstances were, they still have that flexibility to do that, but they should look to the grandparent. If the grandparent is capable, then they should look to the grandparent.
Right. The way the bill is written, it says grandparents or other close family members.
Okay.
So it kind of leaves that part open.
All right, and we have a Senate bill and a House bill, gentlemen, so it would probably make more sense to move forward with the House bill simply because when we passed the May 1st crossover deadline, we want to see the legislation pass, and I'm sure there's no private authorship. Are there any questions of Mr. Schafer?
Mr. Chairman.
Yes, sir. Senator Charles.
Schafer, thank you for taking the time to be here, and certainly recognize this issue probably affects a lot of people throughout the state. I was interested in the last part where it indicates that the court orders expedited placement of child standing towards the other people. That individual may be added as a party. If rights are temporarily removed from a parent and then ultimately are placed back, do you believe the grandparent still should be a party to that action?
Well, the way the bill is written, it would only be as long as there is an open case. If the child was permanently placed with the grandparents, well, that would be pretty much the end of it. Yes. But if the child went back to the parents, I know if it was me as the grandparent, I would think that the ideal situation is, if at all possible, the child should be with the parents and grandparents should be able to be grandparents in the traditional sense. However, if that's just not possible, the grandparents have always been pretty much a soft place to land for a kid when there's problems in the family. And that kind of behooves us to take up the slack where the parents are not able. And if that means permanent custody or even possible adoption, well, then that's the way it should be.
I guess my point is that in rare circumstances, and I think I've seen this down in Charleston, although I don't practice in family court, but I can recall requests by grandparents to be at the table. And I guess my concern is, I'm not so sure if that's going to be a byproduct of this scenario, but what I don't want to do is open up the floodgates where it's really the parents that are parties to the action, and all of a sudden the grandparents now, even if it was a temporary basis, are now added. I think you guys try to really limit it, and actually it seems that the court could remove them as a party if it's not really appropriate. But I envision that, again, and I respect it tremendously, the desire of grandparents to be involved in the love and care of their grandchildren. Just the same, I think you and I could agree that there are probably some kind of overzealous grandparents out there that really want to be involved. And I just hope this doesn't necessarily give that opening when really it shouldn't be necessarily involved. But I know the intent is not that. So I appreciate again your time being here and talking.
Thank you, sir. I agree with you. The intent is to be able to be that soft place. Overzealous, I like to call them helicopter grandparents, need not apply as far as I'm concerned.
All right, thank you, Ms. Schafer. We've got a few other people that want to testify. So thank you for being here today. I wouldn't note, Senator Carlson, in my experience in 20 cases within the court, it says when a grandparent or anybody else is temporary custody is placed with them, they are made a party.